Okay, elected officials cannot just arbitrarily approve or deny land use applications. And here is a specific code with the Idaho statutes. And this is why they have to be very careful, because if they need to have everything in writing, they need to have all these staff reports as a matter of law, because you'll see here in this code it provides a way for the landowner or the person requesting the development of the land, or you say developer, to submit a request for a judicial hearing based off of this code. So Title 67, State and Government State Affairs, Chapter 65, Local Land Use Planning. Approval or denial of any application to be based upon express standards and to be in writing. 1. The approval or denial of any application required or authorized pursuant to this chapter shall be based upon standards and criteria which shall be set forth in the comprehensive plan, zoning and ordinance, or other appropriate ordinance or regulation of the city or county. Such approval standards and criteria shall be set forth in express terms in land use ordinances in order that permit applicants, interested residents, and decision makers alike may know the express standards that must be met in order to obtain a requested permit or approval. Whenever the nature of any decision, standard, or criterion allows, a decision shall identify aspects of compliance or non-compliance with relevant approval standards and criteria in the written decision. 2. The approval or denial of any application required or authorized pursuant to this chapter shall be in writing and accompanied by a reasoned statement that explains the criteria and standards considered relevant, states the relevant contested facts relied upon, and explains the rationale for the decision based on the applicable provisions of the comprehensive plan, relevant ordinance and statutory provisions, pertinent constitutional principles, and factual information contained in the record. A. Failure to identify the nature of compliance or non-compliance with express approval standards, or failure to explain compliance or non-compliance with relevant decision criteria shall be grounds for invalidation of an approved permit or site-specific authorization or denial of same on appeal. Any applicant or affected person seeking judicial review of compliance with the provisions of this section must first seek reconsideration of the final decision within 14 days. Such written request must identify specific deficiencies in the decision for which reconsideration is sought. Upon reconsideration, the decision may be affirmed, reversed, or modified after the compliance with applicable procedural standards. A written decision shall be provided to the applicant or affected person within 60 days of receipt of the request for reconsideration, or the request is deemed denied. A decision shall not be deemed final for purposes of judicial review unless the process required in this subsection has been followed. The 28-day time frame for seeking judicial review is tolled until the date of the written decision regarding reconsideration or the expiration of the 60-day reconsideration period, whichever occurs first. 3. It is the intent of the legislator that decisions made pursuant to this chapter should be founded upon sound reason and practical application of recognized principles of law. In reviewing such decisions, the courts of the state are directed to consider the proceedings as a whole and to evaluate the adequacy of procedures and resultant decisions in light of and practical considerations, with an emphasis on fundamental fairness and the essentials of reasoned decision making. Only those whose challenge to a decision demonstrates actual harm or violation of fundamental rights, not the mere possibility thereof, shall be entitled to a remedy or reversal of a decision. Every final decision rendered considering a site-specific land use request shall provide or be accompanied by notice to the applicant regarding the applicant's right to request a regulatory taking analysis pursuant to Section 67-8003 Idaho Code. An applicant denied an application or aggrieved by a final decision concerning matters identified in Section 65-6521I subsection A. Idaho Code may, within 28 days after all remedies have been exhausted under local ordinance, seek judicial review under the procedures provided by Chapter 52, Title 67 Idaho Code, and appeal shall be from the final decision and not limited to issues raised in the request for reconsideration. And then there's a bunch of history. So yeah, can't just be arbitrary. So anyway, I hope that gives some insight about, kind of the tough sandwich position, so to speak. Because, us as voters, we may not really care, right? We just want the development stopped, or we don't want so much traffic, and you have the issue where ACHD, the Ada County Highway District, is saying, oh, the traffic will be fine, but you don't necessarily agree. Maybe their studies are flawed. Maybe the studies were done 5 years ago. You have the sewer district doing their analysis, and then you have the issues with the CUNA school district, which may or may not be part of the consideration process within the ordinances of the city. So all of these things need to be written out. And so sometimes what may be better is if schools really are that kind of a concern, then an ordinance should be made regarding how full they are. But then now you run into other issues. I don't know the full Idaho code, and the city attorney probably does. If they have an ordinance that is against state code, then somebody would challenge it, likely a developer, and challenge it in court and have it overturned. And all of these end up costing legal fees that end up the CUNA taxpayers end up paying that. It comes out of I'm guessing, the general fund. So you can see it is complicated. It does start involving state politics as well, because obviously, for example, if you didn't really have all of these details or the appeal process, maybe that means, and you remove all of that from every single code in Idaho code, maybe that opens the door for elected city officials to arbitrarily approve, remember that, and deny. So that you are opening up a Pandora's box when you start saying you give them the right to arbitrarily approve it, because now suddenly you have these developers, really trying to get some questionable, super high density, get some really corrupt politicians in, just approving things, even if everyone's saying, it's going to be too crowded. What are you going to do? And then, they end up getting some board position or get paid out in some other way. Maybe they got an NFT to sell. Maybe they got a nice, beautiful, they're a painter, and somebody just mysteriously pays $3 million for this beautiful painting. So it's probably better you have all of these ordinances, all of these requirements public, and everyone looking into it, make sure everyone's doing what is agreed upon, out in the open, transparent. All right, have a good one.